Testing, testing. 1 2 1 2 testing.
Good morning, everyone. Welcome. Our first case for argument this morning is Richard Schneider versus Kevin Carr. Mr. Cade, good morning.
Good morning, Your Honor. May it please the court, Nate Cade appearing on behalf of the appellant Richard Schneider. Richard Schneider unfortunately learned the hard way that social media is not what it's cracked up to be, and that not everyone you intend or interact with is your friend.
Mr. Cade, forgive me.
Yes, Your Honor.
I hate to interrupt you before you've even taken a breath, but there is an active case pending in Wisconsin State Court. Shouldn't we abstain until that case is decided?
No, Judge Rodner, and the reason I know the court asked for some information regarding abstention, those cases are entirely separate. There's only one small portion that might overlap, and that small portion deals with the issue of due process. Obviously, there's a due process claim in the federal court. There is also a due process claim in the state court. But other than that, there is no overlap. There are facts, but the state court, the only thing the judge can do there, it's being briefed, and my understanding is later in March, is indicate to WERC, W-E-R-C, that they should have another hearing. And there, the only thing that can happen is they could say he gets his job back, they can change some of the underlying conditions in terms of what takes place, etc. But they can't decide the First Amendment issue. Only this court can. And the damages are entirely different. And I can go into the damage issue, obviously, because we've got the Seventh Circuit jury instruction on damages, which is entirely different than the relief that can be provided in state court. In fact, state court can't even award attorney's fees with regards to the underlying case.
Is the case in state court a Chapter 227 review?
At the current stage, it is, Your Honor.
Okay. And that the scope of that review and the relief available consists of what? And I know in that sort of a proceeding, constitutional claims are permissible and can be joined with the Chapter 227 review.
They can be, but again, it's a separate issue in terms of the First Amendment. All that court can do, as I said, is they can award wages for back pay, potentially front pay. They can have him reinstated. They can issue some sort of order to the Department of Corrections indicating that their actions are inappropriate, etc. And some of that is moot because at the time Mr. Schneider was suspended, there was no internal policy at DOC regarding Facebook and social media. And as soon as he got suspended, they developed a policy and implemented it. So,
and is front pay, or are front pay damages and back pay damages being sought there?
Well, initially what we are seeking is for him to be reinstated. So that's first they have to decide whether work was incorrect. Does he get a hearing? And then theoretically work can say, yes, he gets reinstated, and if he gets reinstated, then we have to do damages. So it's a multi-step process there. But that's different than the damages being sought here for the First Amendment violation.
So it has to be it has to be back to the agency before the court can award any front pay or back pay or
That's my understanding. I have a colleague handling the state claim because I don't normally do employment issues there, but they would have to indicate work upheld the termination, and so the state court under 227, the only thing they can do is say whether it was just cause. And if they say it wasn't just cause, they send it back to work with specific instructions, and then work potentially would have either another hearing, or they may say circuit court overruled us, and now we're going to say there wasn't just cause, so he has to be reinstated, and then we get into the issue of damages. We never discussed damages when we had the initial work hearing. It was just whether they had the appropriate authority to terminate him or not.
I'm still a little concerned here. I don't mean to be simplistic, but what happens, for instance, if the state court rules in favor of your client and orders reinstatement, and we rule against him, or vice versa? Are you saying that's not possible under the scenario that you're painting?
No, what I'm saying though is those are entirely different issues. So if, for example, he is reinstated by the state court, then that's just that they didn't have cause to terminate him. Here, the issue is First Amendment. So did they violate his First Amendment rights as a public employee? This court could turn around and say, because he is with DOC, his First Amendment rights may have been limited. But that's a different story as to the termination, because the state court could say there wasn't just cause.
Wow. Oh,
You're seeking
Well-
reinstatement in this action as well. That's one of the forms of relief.
Well, it was one of the forms of relief until the state claim was thrown out. So because we filed both the state and federal in one court, and then once the court ruled against us, Judge Peterson, really the only issue in this court is the First Amendment and the due process, because reinstatement, I don't know if this court has the authority to.
Well, right, not this court, but what you're asking for is that what you're asking us to do is to reverse the summary judgment and remand for a trial on the First Amendment claim,
Correct.
in which you would request damages and equitable relief in the form of reinstatement?
No, because the state court claims have been lobbed off. So unless somehow, and I haven't seen it, unless somehow the state court could send it back to federal court, if they said, hey, it's come back and now we can hear it, the only thing that would remain in federal court, because the state court claims are gone, would be the First Amendment claim. So it would just be damages. And the typical damages that are found in 601 of the jury instructions. So, humiliation, all the different things, things that are supposed to be compensatory, but not wage loss and things of that nature.
Mr. King,
Are you saying that the state court cannot make factual determinations that would affect a federal court's view of the case here? Are you saying that?
No, Judge Rovner, I'm not saying they can't make factual determinations, but what I am saying is those are two separate issues. You could have a state court make a determination that he can be reinstated and they didn't have just cause to terminate. So what they did here is they jumped to termination. They have a step procedure and they didn't follow the step procedure. He had zero discipline. They went right to termination. The state court work could turn around and say, hey, you should have followed the steps of progression in terms of discipline. That's a separate issue. But I don't think this court can reinstate him. This court could find that he's a public employee and he had certain First Amendment rights, but they could say even if he had First Amendment rights and they were violated, the state court can make a determination that they were justified in terminating him.
Mr. Cade,
Yes.
perhaps taking another kind of tack at this, what remedies then would be available to your client in this court that he could not seek in state court? In other words, he could bring the constitutional claim in state court. He could seek all of these remedies in state court along with reinstatement under Chapter 227. And so what in particular is unique about the remedy that we as a federal court can provide him that he cannot get from the state court proceedings?
Well, Judge Lee, I guess when you break it down, first of all, in the state court, there is no First Amendment claim because that claim was thrown out on summary judgment. So even if this court steps back and says, we're not going to rule on it, even if we're lucky to get work to look at the issue again and say he deserves another hearing or it was inappropriate, the First Amendment claims aren't there before the court. The First Amendment claims were never addressed in the work hearing. When we had it, I believe it was a full day. It may have gone a day and a half. So they were never addressed.
I think the question is whether there are First Amendment, whether it's possible to join First Amendment and due process constitutional claims under 1983 with the Chapter 227 review, and have you done so? It sounds like you have not done so based on
Correct.
between the lines here.
We have not done so, and really all that can happen in 227 is they can only look as to what occurred with WERC. So they can't turn around and say, oh, and now you can add all of these other claims because it was never addressed. If the circuit court reverses, could that issue come up? I'm not an expert in work procedures.
I'm not talking about what the agency decided. I'm talking about the claims that are before the court, the
Right.
Columbia County Circuit Court. And it is possible to join Chapter 227 claims for judicial review of an agency decision with a constitutional claim arising out of that same decision. But it sounds like that has not been done here. You took two separate paths, one in state court and one in federal court.
Well, we took two paths, Judge Sykes, because the bigger issue obviously was we brought everything in federal court. The federal court, Judge Peterson, decided to exercise pendant jurisdiction over the state claim, so that went here. If we did not appeal to this court, then we had possibility of them in state court saying, claim preclusion, because the court has already ruled and you never appealed.
Well, Judge Peterson didn't assume pendant jurisdiction over the Chapter 227
No.
proceeding. That can't happen.
No. When it initially was filed, we had state claims and federal claims all at the same time in the complaint. So he said goodbye to your state claims when he granted summary judgment. So it would be difficult, to turn around in state court to say, okay, now we want to do a First Amendment claim, and the state court judge will say, well, you were in federal court, you lost, you didn't appeal, so therefore,
That's the whole point about the abstention inquiry, because
Sure.
we're on a collision course with the state court, or potentially. But if you haven't brought any constitutional claims in the Chapter 227 complaint,
we have not.
it's solely a complaint for judicial review under Chapter 227. There's no second or third count for First Amendment
Correct.
and due process violations.
None of that, correct.
Okay.
So, yes, it's, I guess, technically possible, but if we don't appeal here, we potentially are barred there, and that's our big problem.
Okay. We haven't left you much time to talk about the merits, but why don't you have at it?
Thank you. So basically, the court is aware of the 5 memes. The district court erred because it made certain assumptions. One of the assumptions it made, it talked about the Facebook memes as being mocking, derisive, and juvenile. And that's basically what 70-80% of Facebook is and other social media.
That
It
would
also
be a
erred-
pretty broad thing for a court of appeals to say.
I'm sorry?
That would be a very broad generalization for the Court of Appeals to say in a legal ruling on this case.
Well, I think the Supreme Court also is grappling with a lot of that because they've had a couple of cases the last days as to what Section 230 means and everything else. But here also the district court erred because it gave deference to DOC. And one of the arguments it gave to DOC was that it would interfere with the cohesion, except there was no evidence of interference with cohesion. All we had was them saying, well, it might interfere. It might cause problems. They never put forward a single declaration or affidavit from an employee saying, I can't work with Richard Snyder, or I can't have him as my boss or over me. In
But the
fact,
case law doesn't require that.
No, the
for
case law-
Pickering balancing, it doesn't require an evidentiary showing of an actual disruption in the workplace or an actual breakdown in cohesion.
it doesn't require an actual, but there is case law from this court that discusses that, there's deference given because it's DOC is considered like the police paramilitary. So there is some deference given, but there's case law that says you have to show something, except when you give deference potentially for the paramilitary. But this court decided a case, Harnischfeger, 943 F. 3rd, 1105 from 2019. And there in Harnischfeger, it was a person employed by the Indiana National Guard. And if anything is paramilitary, it would be the National Guard. And there, the court said, when they made claims, because a woman had published a book saying, well, you've interfered or will interfere, the court said, no, you've got to show a little bit more than just some vague, it might interfere. It's the same thing here. This got posted. We don't know who gave notice to the Milwaukee Journal-Sentinel that this got posted. No one came forward and said, I have problems. And it's not like any of the other cases cited where you could look and say, well, that person, we've had problems with that individual in the past.
But Mr.
They-
Cade, here, your client's part of his duties and responsibilities were to implement the regulations and the laws, make sure everyone was following them, including anti-discrimination laws and other employment requirements. I mean, he had broad authority because of the level of his position. In Harnischberger, there, the book really didn't relate much to the plaintiff's particular duties in the National Guard. Here, your client is expected to oversee a workforce that is very diverse and would presumably include people in the very categories that his memes on their face seem to mock and attack. And so how is it, I don't understand your argument that somehow the memes there's no evidence that would impact his duties to promote cohesion within the workforce or within his staff.
Judge Lee, if I take your argument to the logical step that, well, the meme somehow in this diverse force, what if instead he wore a red MAGA hat and he said, hey, MAGA till I die? And people view that and they could say, well, if he's MAGA hat or he's following along those, we think he's racist.
But he didn't do that, did he? What he did was, one of the memes portrayed basically Muslim children, equating them to bags of garbage. That seems very different than a post of him attending, a person attending a MAGA rally or a MAGA hat. It seems particularly derisive and derogatory. And if he has authority and part of his job is to oversee a workforce that includes Muslims, then how does that meme not relate to the fulfillment of his responsibilities?
Well, again, I think that if you take that to its logical extent, then anything that he does on social media that tends to favor one side of, say, the political aisle or something else, someone could say, well, that implicates your duties. What does MAGA stand for? Make America great again. Go to the border. Let's stop the Muslims from coming in. We're going to have bans. All of that is equated. If I see someone with a MAGA hat, I have certain beliefs as to what they think.
First of all, I think that I'm sure there are a lot of people in this country that would disagree with your association of a MAGA hat with all of those various connotations. But it seems to me that to the extent that his responsibilities include implementing and overseeing, for example, anti-discrimination laws, those anti-discrimination laws don't particularly identify people with different political persuasions as protected groups, but it certainly includes people of different races, religions, as well, and similar factors. And so it seems to fall squarely within his responsibilities.
Well, Judge Lee, I know I'm out of town, but again, if he turned around and didn't have a MAGA hat, but he had something showing that he was a fundamental Christian, and he posted on there that Jesus Christ is his savior, if someone is of Muslim origin, they could turn around and say, I think you might discriminate against me. It's the same analysis. The point is, he had no problems prior. There wasn't any questions. One of the issues was the LGBT flag. He oversaw, as a deputy warden, 14 prisons. Governor Evers had allowed, back in June of that year, for the prisons to, if they wanted to fly the LGBTQ flag. He was the only one who authorized it to fly at the prisons. So it's hard to reconcile saying, oh, well, he's got a meme there about flying flags when he's the one who's turning around and authorizing the very same flag to fly. There is no evidence that he had done anything improper. No one came forward and said, I think he was discriminating against me. I think he did this issue against me. It was
I'd like to take you just for a minute. I know we are going over your time, but is it your view that we need to have someone complain before we think a work behavior is disruptive? For instance, if an employer belittles and harasses her employees every day and they're all too scared of losing their jobs to complain, but the HR director actually overhears it, should the HR director say to herself, well, no one has complained, so it must not be disruptive? I don't understand that argument, you see.
I'm not saying disruptive, but the difference here is he wasn't fired immediately, Judge Rovner. They investigated. And one of the issues with the investigation, I believe it was the Harnischfeger case, where it was a 4-month time period. Over those months, they found nothing in their investigation. So they didn't find anything to suggest that there had been a lack of cohesion, or people had complained, or there had been any problems. And that was one of the centerpieces. So if they had just said, hey, you're fired, then I would agree with your argument. But if they're taking the steps of investigating, then one of the things is to find out, do they have other means to uphold the termination based on the First Amendment?
Okay. Well,
I don't know how much time I have left, but thank you.
Thank you. No, I'll restore some rebuttal time.
Thank you.
Mr. Kilpatrick.
Good morning, Your Honors. Good morning, Your Honors. May it please the Court. My name is Stephen Kilpatrick, Assistant Attorney General with the Wisconsin Department of Justice, appearing on behalf of appellees Kevin Carr, Amy Pahacek, Magda Fesahay, and Carrie Beyer. After listening to counsel, I believe that there is a relatively easy way to dispose of this case, possibly without getting to the merits or to abstention, and that is by qualified immunity. What I heard from opposing counsel was that all that is left here are damages claims. And if that is the case, he has sued the appellees in their individual capacities. We have made arguments in our brief that qualified immunity applies. The court does not need to determine whether a constitutional violation of the First Amendment or due process occurred, can skip to the second step of qualified immunity, and the inquiry would be whether there was any clearly established law that the 4 defendants would have been placed on notice that the actions that they took against Mr. Schneider at that time would have been in violation of the First Amendment free speech clause prohibiting retaliation or the due process clause. So if, and
I take it that because you're starting your argument this way, that you agree with Mr. Cade that we should be hearing this case, even though there is a parallel proceeding in the state court that it involves essentially the same parties. You agree with his position? Am I correct?
Yes. Our first position is that this court can affirm on alternative grounds because the district court did not reach qualified immunity. It went ahead to the merits, but this court could reach on alternative grounds qualified immunity. And if that were the case, then I believe, from what I've heard opposing counsel say, there are no official capacity claims remaining that would have any type of prospective relief that could interfere with any of the state proceedings. So I do believe that abstention can be avoided altogether if there were a qualified immunity ruling by this court. I'm happy to answer questions about the merits and abstention. I'm not trying to say that I won't, but I believe that there is a relatively easy way to dispose of this case now.
Is the record clear on the forms of relief that remain live in the case? Or
in the federal case?
Yes, in our case.
There were, in the complaint, there was a request for reinstatement.
I thought so.
And from what I heard just now, it sounds like there is no claim for reinstatement anymore. And if that's the case, then all the complaint asked for otherwise were damages, compensatory damages under 1983, as to these 4 individuals in their individual capacities. And in briefing before the district court, I point, and I think we've made this case argument in the brief, is that as to the due process claim, the plaintiff did not respond to the raising of the qualified immunity defense by the defendants, and therefore forfeited that argument. And here before this court, if you look at the reply brief, the plaintiff appellant cited no cases, none, in response to the argument that the defendants raised with regard to qualified immunity as to both constitutional claims, the First Amendment retaliation and the 14th Amendment due process. So it's our position now that once qualified immunity is raised, it is the burden of the other side to point to cases that would have shown these four defendants would have been on notice that the actions that they were going to take against him, Mr. Schneider, would have violated clearly established First Amendment retaliation law and due process law.
I was a little unclear about the nature of the due process claim based on what went on in the district court in the briefing here. It had overtones of a substantive due process claim, actually challenging the content of DOC's rules to the extent that they don't provide any guidelines for social media use.
Right.
That's a substantive claim about the content of the rules. That's not a process-based change. In other words, you didn't give me a hearing. Two different kinds of claims.
Right. The different aspect of that type of a due process claim, it was clearly wasn't briefed before the circuit court and wasn't briefed before this court. The district court took it as a procedural due process claim. He wasn't put on notice. That was the way that Mr. Schneider argued it. He wasn't put on notice that what he would have done would have subjected him to termination. And that's very similar, I agree, that's very similar to what he's raised in state court, in the state court proceeding, is that the work rules that were referenced in the termination letter and in the pre-disciplinary hearing didn't encompass a social media policy. They didn't reference what a person can and can't do on social media. But it's our position that the district court was correct in that the work rule, at least work rule 25, was clear that what someone does outside of work, their position, that could have a detrimental effect on their, that was sufficient notice.
Yeah, in general terms, but there's no social media policy in DOC at the present time or at the time of this termination.
At the time of the termination, right? There was no policy. There is one now.
Okay.
But I do disagree with opposing counsel that the fact that there is one now somehow bolsters their case for due process. I don't believe there's been any case law cited for that proposition.
And for clarification, the Chapter 227 judicial review proceeding in Columbia County is purely a matter of state law. There's no federal constitutional claim in that case?
As far as I can tell, yes, Your Honor, because the WERC, Wisconsin Employment Relations Commission, was tasked at determining whether the Department of Corrections had just cause to terminate his employer, his employment, Mr. Schneider's employment. It didn't have the opportunity to hear a due process claim.
Right, but the circuit court would if such a claim were joined with the Chapter 227 complaint.
That's correct, if it were joined, and it has not been joined.
Okay.
All that's before the Columbia County Circuit Court is a Chapter 227 judicial review action. Okay. So it is a limited, in Wisconsin, it's a very limited type of review. The trial court essentially sits as an appellate court. There is a closed record of the evidence that was submitted during the contested case hearing before the commission, and the circuit court then looks at that closed record and determines whether the conclusion of the commission was correct. And the commission concluded, after the district court issued its decision, concluded that the Department of Corrections had just cause to terminate Mr. Schneider's employment, as that term is defined in the statutes and in case law. And
so if we find that you're correct as to qualified immunity, what is your view of the next steps in the state court proceeding?
Your Honor, I believe that the state court proceeding can continue. I don't believe when we were tasked with determining whether there were any parallel state proceedings and what doctrines of abstention were to apply here. I'm not sure, and I don't think that these cases in state court and federal court are truly parallel. There are different claims, as I explained. The federal court has Section 1983 First Amendment retaliation claims and 1983 due process claims. And neither of those claims are attached to a Chapter 227 judicial review action in Columbia County. And there wasn't a First Amendment retaliation argument made by Mr. Schneider in the proceedings before the commission. There was reference to due process, but it was more of a argument that the work rules that were cited in the letter didn't provide him with sufficient notice. That is what, under a just cause standard, a just cause hearing, the commission can only determine. The commission determines whether the employer proved its case under a just cause proceeding in front of the commission. The employer has the burden to show that it meets its burden in showing that there was a violation of these work rules. And if that's the case, then the commission determines whether there were sufficient grounds to implement the level of discipline imposed. And here, that level of discipline was termination. And the commission determined that was the case, again, after the district court issued its decision.
How much deference do we give to an employer's assessment of what is disruptive?
The short answer, Your Honor, is a lot. The case law shows that local law enforcement agencies and prisons are given deference. Case law shows from this court and from the Supreme Court that prison officials don't have to wait for a disruption to occur, but can make reasonable predictions. That was in Connick and also in Waters v. Churchill. Also, I want to point out that in this case, Mr. Schneider was suspended with pay immediately upon the department finding out about the Facebook reposting of the memes. So there was no opportunity for any type of disruption to occur because he was no longer on duty. He was no longer on premises during the 4 months or so of the investigation prior to his dismissal. So I believe that the lack of evidence of disruption does not sink the defense or the outcome issued by the district court here.
Mr. Kirkpatrick,
Yes.
I understand that the department also has a progressive discipline policy, and that the progressive discipline policy, the department elected not to go that route. And can you provide me with some more information with regard to that, please?
Yes, Your Honor, and it is our position that that is irrelevant for the purposes of a First Amendment retaliation or due process claim. Those are strictly state law issues. Just cause has recently, within the last few years, attempted to be defined in state statute. There are now certain lists, I don't believe they're exhaustive, of certain types of actions that can be taken without imposing progressive discipline. So as a state employee, if you are found to have violated a work rule, you may get a 1-day suspension, then a 3-day, then a 5-day, and then maybe discharge. And there are circumstances in which progressive discipline may be avoided. And this was one instance in which the Department of Corrections decided that it was that special case where progressive discipline could be avoided. But that, Your Honor, is for the Wisconsin Elections Commission to determine. As I said before, as part of the just cause inquiry, so one is whether the work rules were violated. The second inquiry would be, what was the proper level of discipline? Was there just cause here to terminate Mr. Schneider's employment? And after the district court issued its decision, the commission said yes. So for the purposes of abstention, Your Honors, is we believe that there are not parallel claims. And so likely the Colorado River abstention doctrine wouldn't apply. And I don't think the Younger abstention doctrine applies either.
How does the qualified immunity inquiry map onto the substantive First Amendment claim in this case, which is governed by a multi-factor balancing test in which the factors are unweighted and
Right, may
discretionary
Right, may I
and
answer?
non-exclusive, please?
Yes, Your Honor. So for the purposes of qualified immunity, case law teaches that it's a fact-intensive inquiry. And here, under Pickering balancing, that also is fact-intensive and multifaceted with regard to different balancing factors.
That suggests that qualified immunity will never be pierced in a Connick-Pickering speech retaliation case.
Well,
because everything depends on facts. Nothing depends on law.
Well, in this case, Your Honor, I don't believe that there's any cases, and I think it's just the opposite. We cited our Lolosky, this court's Lolosky decision. So for First Amendment purposes, how were the four defendants to have known that terminating Mr. Schneider's employment or taking action in the due process and the procedure would have been violative of his First Amendment rights to be free from retaliation? I don't believe that there's any case law that would have put them on notice that that was something they could be liable for under 1983 for damages.
All right, thank
And
you.
with that, I ask the court affirm. Thank you.
Thank you. Mr. Cade, I'll restore your rebuttal time that you had reserved. We kept you busy with abstention questions.
Thank you. I will quickly follow up with what my opposing counsel had there. I do want to start with, he said there was nothing putting them on notice. I would disagree. Harnischfeger came out. It was out there in 2019 before any of this took place. And the key in Harnischfeger was it was on the Ms. Harnischfeger's private Facebook page, just as this was. The only reason it came to light is because it was in the Journal Sentinel. So had they read the Harnischfeger case, they would have said, hey, it had nothing to do directly with work. He didn't identify anywhere that I am a member of DOC or I'm a supervisor and I'm taking these bad actions. Nothing. It was on his own time, private Facebook page. So that, at a minimum, should have put him on notice that something improper could take place. More importantly, Judge Lee, you had asked about the progressive discipline. He got terminated after the then Lieutenant Governor Mandela Barnes posted, hey, this guy should be terminated. He shouldn't be working for the state at all, right? If the work rules were so clear, then that should have put everybody on notice. But no one was on notice at DOC what was or is not improper or violative of this work rule, because the work rules are vague. In fact, one of the points that I raised in deposing Ms. Fesahaye is she's very active on social media. We're socially friends. My child and her brother went to grade school together. But she has a number of posts where, for example, she was posting about another attorney, a friend of ours, who had done well, but he also has been in the newspaper because he was the attorney and may have violated some ethics rules with regards to a person who might have committed a rape. So my argument to her was, well, if you're supporting somebody who is tied closely as a client and as a colleague because they have a joint development for someone who's committed rape, doesn't that mean that if someone has a problem with sexual harassment, they don't come to you? I mean, that's really what the argument is hey, the mean means this, so you can't tie all of that together. Leslowski has nothing to do with this case because the sheriff's deputy, the officer, actually had gone to the crowd first in uniform, had raised some statements. He had called a woman a fat cow because they were anti-abortion protesters and made some other statements. Then he went back later on and said to them, "Do you remember me?" And they said, "Yeah, you were the cop who was here earlier." None of this was suggested that Snyder was working for DOC or was involved with DOC. And finally, qualified immunity doesn't apply, as I said, because they certainly had noticed that violating someone's First Amendment rights could cause problems. Harnisch-Fager is very clear on that point at 1120 and 1121 that it's a general audience that should put them on notice. Thank
And
you.
just to clarify, to the extent that there's any doubt, there's no longer a claim for prospective relief in this case.
That is correct. And I did pull up, I had someone send me the work complaint. All it said in the work complaint, it was 6 paragraphs, I think 7 paragraphs, and it was just that the hearing
I'm talking
exam-
about in this case.
Correct. But you had asked earlier about what the relief was. The only argument there was that the hearing examiner was biased and work turned around and affirmed. So the only issue the circuit court judge in Columbia County is taking up is, did work have a basis to uphold the hearing examiner, and was he biased?
All right. I think Judge Rovner had a question.
Did you forfeit the qualified immunity argument?
I don't think we did, because I don't think the district court dealt with it, and I don't think there's a argument. I don't think we forfeited it.
Thank you.
All right, thank you very much. Our
Thank
thanks
you.
to both counsel. The case is taken under advisement. We'll move to our second case this morning, Peter Nelson versus the Town of Paris. Ms. Nicholas, good morning.
Good morning. May it please the court. This case concerns an ordinance enacted by the town of Paris, Wisconsin, restricting where persons with past convictions for certain sex offenses are permitted to reside. This ordinance is unlike anything that has been upheld by this court or any other court. It prohibits persons with certain past convictions from living within 6,500 feet of a variety of protected locations, which includes not only the traditional child-centric locations like daycares, schools, and playgrounds, but also encompasses recreational trails, parks, and places of worship. And in addition, it prohibits registrants from residing within 6,500 feet of one another, a restriction that has never been considered by any court.
Ms. Nichols, is it allowable for a court that is balancing excessiveness to consider housing possibilities just outside the boundaries of town? For instance, okay, a former offender could live 50 feet from a daycare if, for example, the offender lived on the Bristol side of the town line and the daycare was just across the line on the Paris side. Is that right?
That's a very interesting question, Your Honor. And the truth is, different municipalities do this differently. Some municipalities do look outside their own territorial boundaries to figure out whether there are locations they would consider protected close outside their boundaries, and then they would establish protected zones around those too. I don't know whether that's something that the town of Paris seeks to do. However, I would say more broadly, it does not make sense to look to the availability of other housing options elsewhere, because these communities that are enacting residency restriction laws are responsive to one another. And so if an ordinance like the one that the town of Paris has adopted is upheld, that will of course lead to other municipalities that do not want to become a haven for individuals with sex offense convictions who have been banned from their homes in Paris to move to the neighboring municipalities. So I think that where the district court erred was finding that it was bound by this court's previous decisions in cases like Vasquez and Hope to find that this ordinance was not excessive under the ex post facto clause.
So, Ms. Nicholas, what I struggle with in these cases, and comparing them to Vasquez and Hope and whatnot, is trying to come up with some sort of either rule or limiting principle that we can provide to towns and other municipalities out there as to what is allowable and not allowable, right? And so here, it appears that if you take, I'm going to call them subsection A, which is the one that deals with proximity to other sex offenders, and subsection B, which is proximity to protected locations, okay? If you take both of them together, right, it appears there's still, the town claims 42% or something like that of residences available to registrants. You say that's not enough because of various reasons, kind of various theoretical reasons, actually. What sort of, first of all, where is the line and how does the court go about drawing that line?
So I think that where the district court went wrong was putting the focus on the availability of that 40% of housing. And there's a couple of reasons for that. First, I just think it's the wrong inquiry. There are plenty of restrictions that a municipality could enact. For example, no registrant can live within 6,500 feet of a member of the town board. That might still leave 40% of the town's housing in allowable zones, but it would still be necessary for this court to properly apply ex post facto analysis to look at the fit between the non-punitive objective being advanced and the restriction that the municipality decided to enact. So I think that the 40% standing alone doesn't tell you too much about whether this ordinance should be seen as imposing a punishment that violates the ex post facto clause. And the second reason that's really not or it's not the principal measure that should be looked at, is that you have to look at the practical effects of an ordinance like this, which is that the town has creatively targeted the only rental housing it has. So by creating these floating restriction zones around registrants, it ensures that registrants will not be able to live there.
Well, so hypothetically, let's take subsection A, that floating protected zone, out of the picture, okay? And let's just say the town only has a restriction that a registrant cannot live within 6,500 feet of a protected location, right? And presumably that would leave more than 42% available, because I think that includes both provisions. In that case, in that situation, do you think that 50% would be enough? Is 60% enough? What percentage, what are the metrics that we're supposed to look at?
So I think that what the court needs to examine is the relationship, the fit, the proportionality between the restriction that's being imposed and the interest that's being advanced. So in Vasquez, for example, this court looked at a 500-foot restriction and said, there's a self-evident connection there. We don't want people who have offended against children living in very close proximity to places where children are known to gather. With the ordinance we've got at issue here, we're starting to take a few steps back from that, and the relationship between the public safety goal and the restriction imposed is getting more and more attenuated. Now we're looking at 1.25 miles from these protected locations. And not all of the protected locations are child-centric locations. And not everyone who's subject to the ordinance is someone who's offended against a child. So really, what I think the courts should be more sensitive to in these cases is the excessiveness factor of the Smith analysis, which requires for a little bit of a more searching inquiry into why this restriction has been enacted and what relationship it has to the articulated public safety goal. When you look, for example, at the restriction on individuals living within 6,500 feet of one another, the town has given a very theoretical, somewhat strained explanation of how this is going to advance public safety goals. It relies on a series of presumptions. If these individuals live within 1.25 miles of one another, they may meet one another, they may form associations with one another, they may influence each other to act in antisocial ways. When you are relying on that string of assumptions or speculations, it starts to look like something that the court needs to take a closer look at the evidence underlying that restriction and whether it is proportional to the interest being advanced.
I mean, I agree that I think that the appellant has a stronger case on the floating zones for a variety of reasons. But let's focus on, for now, on your harder case, which is just the zones around protected locations, right? And so one of the things you offer about in your briefs about why 42% is not sufficient, 42 or greater, is that Mr. Nelson would not be able to afford any of those tracks, right? But there's no information in the record as to, for example, what the average sex offender that would come into a municipality like Paris would be able to afford. Nor do we have any sort of demographic information with regard to incomes of other residents in the town, because certainly maybe other people can't afford those tracts as well, but then they have a large mortgage. And so I'm just trying to grapple with the broader notion of what sort of facts does a court like us need in order to make a determination under Smith as to whether or not the locations, or buffers around protected locations, would pass muster.
It's certainly not easy, and there is a lack of clarity and lack of specificity in the Supreme Court's decisions about excessiveness. There isn't a clear test, and there isn't clear language for this. I think there are a few guideposts that a court analyzing one of these laws could look at. One is that the city has been frank about the fact that its purpose here was to target the only rental housing that is in the community. And it did that because the Wisconsin Department of Corrections had realized that these were affordable.
But again, but my understanding is that those motels are not subject to subsection B, right? They're not within 6,500 feet of a protected location. And so again, I understand why you want to go back to your stronger argument, but I want you to focus on the other one. And so should we look at the percentage of available housing? Should we look at economic factors? We're supposed to look at these not as applied, but on their face. And so as we do that, how do we go about this line drawing that you want us to do?
So I think there are a few things the court can look at. One is these types of restrictions are not new. Communities have been enacting residency restrictions for over 30 years at this point, and the statewide restrictions range from 300 feet to 3,000 feet. That has been deemed by state lawmakers to be within the realm of what they've deemed necessary to advance their public safety goals. This is something that is far out of proportion with that. It's multiples higher than the restrictions imposed on state levels or by surrounding communities. So I think that's one thing the court can look at. The other, I think...
No, finish your thought.
Another thing is the basis the town is giving for this. It seems to reveal that this is an excessive regulation because their own witnesses said they had no basis to believe that 6,500-foot restrictions were more effective or did a better job advancing their public safety goals than 1,000-foot restricted zones. And in fact, they simply wanted to enact larger zones because 1,000-foot zones didn't bring enough within its purview. So I think those are the types of facts that the court can take into account when trying to analyze whether this is an excessive restriction in relation to the public safety goals that are being advanced here.
What about the grandfathering clauses, which make the ordinances less restrictive than those in Vasquez and Hope in some ways? How do we factor those in when we assess how restrictive this ordinance is? And my second question to you would be that the town tells us that 13 offenders have lived in Paris since the ordinance was passed. And is there anything in the record about why there are only 3 now?
So I think grandfathering here has limited applicability to whether this ordinance is punitive on its face. And that's because it's no help for someone like Mr. Nelson, who didn't establish his home prior to the enactment of this ordinance, didn't establish his home prior to the other registrant establishing a home within 500 feet of him. So I think that when you're looking at a facial challenge, the existence of those grandfathering provisions isn't all that relevant. And then with regard to there only being 3 individuals there now, it seems apparent that with these floating restriction zones, if you have 3 people, you're really putting the entire city off limits, because there's 2.5 miles around each of them within which another person cannot live. So even if somebody finds a residence that is within the allowable zones outside of the 6,500 foot exclusion zones, once they establish a home there, you're putting a floating buffer zone around them into which no other registrant can reside. So
but I still don't understand what happened to the 10 others. I mean, they were there, and now they're not.
I do not know what happened to those individuals, and perhaps counsel for the town can answer that. But if it's okay, I'll reserve the remainder of my time.
Fine.
Thank you.
Thank you. Mr. Wool?
May it please the court, Attorney Dustin Wool for the town of Paris. I'll start just with some notes that I made during the previous argument. There was talk about that the ordinance is excessive because it hits places that aren't frequented by children. There's no factual basis for that. In the depositions, this is a really small town, and the way the ordinance was passed was everybody knows where kids associate. So one might be a church, but they know, hey, that church runs a daycare. So there's no factual support for the argument that just because it says a church or a library, that those aren't places that actually aren't frequented by children. Along similar lines, one of the reasons for the distance that was chosen is the rural nature of the town. And I know, not every rural town has chosen to go with that size of a distance, but there was testimony that there was a concern that kids will go in groups unsupervised by parents to a place that's a protected zone by themselves. So there was a concern that something had happened along the way, which was one reason for the larger buffer.
Mr. Wool, what the peculiar aspect of one of the peculiar aspects of the ordinance to me is this notion of what referred to as floating buffer zones, right? At some point in time, given the 6,500 feet buffer zone that's required around a registrant once he or she moves in, at some point, I don't know if the town has done this analysis or not, there's just not going to be any residences available, right? Effectively, and that would, under our cases, effectively amount to banishment. Because if you're a registered sex offender and you want to live there, there's just no place for you to live. Now, perhaps if a couple of those people move out, there is. But at some point, the ordinance envisions a time when there simply will not allow any registrants to live in the town, right? And so why isn't that banishment, and why isn't that something that we should consider in assessing whether or not at least that section of the ordinance, Section A, passes constitutional muster?
Sure, that's an interesting question. Right now is a theoretical possibility.
No, but we have to look at the ordinance on its face. And so we look at, when we do this analysis, the way I do this analysis is I look at the ordinance at both extremes. I look at what does the ordinance permit, and also what does it kind of allow in its extremes. And certainly on its face, it allows for this kind of scenario to take place, whether it's in a year or 2 years or what have you, where the town is simply off limits to anyone.
And I guess the cleanest answer to that is the appeal procedure. And that was added specifically in 2018 to give more flexibility and individualized assessment available to designated offenders. So, and that was one of the factors, and in the reply brief, counsel said, well, that's not a factor that goes to the risk of the designated offender, but it's the other, it's the burden, right? If we're going to balance, available housing is one of the factors. So if it came to a place where the bubbles were such that there was, every place was off limits and somebody wanted to move in, that's a factor that can be taken into account for the appeal. And at that point, they might say, you know what, that's, assuming that there wasn't a high risk, that would weigh in factor of allowing somebody to live.
So let's say a hypothetical town passes an ordinance that says, you know what, registered sex offenders are not allowed to live in this town unless they go through a hearing process, right? Do you think such an ordinance would be permissible?
It would certainly stand worse than ours does, and that's.
But I guess that's not my question. My question is, do you think that would be permissible under the ex post facto clause?
You would have to go through each of the factors. I think it would probably pass muster because it says, in going through, I think of does it relate to a traditional means of punishing, right? And ours is regulations that say where you can live, and then there's some flexibility built in. I thought it was really interesting that the Supreme Court said the reason that this is a factor is because if a town passes a law like this, they want to tell everybody that what we're doing is punishing. So they're going to pick something that looks like punishment. The law you mentioned where it says nobody could come in and there's a back door that you can do, that sounds a lot more like we don't want people in. So here, it's ours is in a better stead than that. So I think if you were to have a flat out ban and say, but there's exceptions, that signals, hey, we're trying to punish.
But isn't that what will happen at some point under the current ordinance? There'll be a flat out ban. And what you're saying is they can get exceptions by going through the appeals process.
I think part of it is that I know we're looking at the possibilities of what could happen. The law has been in effect since 2008. It hasn't happened yet. And the idea, the question is, where are those people? There have been 13 that have lived here. Currently, there are only 3. So it hasn't happened yet. The town hasn't been faced with that possibility. And quite frankly, if they had been faced with that issue, they might very well have said, let's have a different buffer. I think they probably just picked the same buffer that they had for the protected places.
I do not understand your argument about the appeal process because what would the appeal process do to save the ordinance if in fact it may be unconstitutional? The appeal process puts the outcome in the hands of members of the town board who can assess myriad factors, including extremely objective ones like level of remorse, credibility of the offender, current dangerousness. I don't understand how an offender could ever win an appeal process where this kind of subjectivity could easily mask a true intent to just keep former offenders out of Paris. And there were 13 and now there are 3. So I'll ask you the same question. Where are the other 10 now?
Yeah, thank you. Starting with the first issue, the appeal process. It's interesting that it hasn't been tested here. In this case, there's a provision for certiorari review, and the factors all do relate to things in determining in a particularized manner what the risk is for a particular offender. And that was, certiorari review, one of the big ones is if the board exercised its will instead of its judgment. Here, they all factored in. Mr. Nelson had committed parole violations. He had firearms violations. He was living without following the law to register for 2 years. So there were all, good reasons. Mr. Nelson or anybody could challenge that if somebody just said, if the board, just said, we're going to do it, we don't like you or whatever. If they couldn't come up with anything that factors into, it's required to look at the risk that the person poses. So I think that it's not just window dressing. There's the certiorari review, and it hasn't been tested yet. We put that in to add flexibility and an escape valve. If we had facts that suggested, there was a bunch of appeals and all of them got rejected for reasons that seem frivolous, then you could say, yeah, that's a dead letter. It's just window dressing, that it's toothless. There's no evidence here that the appeal is toothless. Mr. Nelson was the first person, the only person that's ever been cited under the ordinance. There's these arguments that people can't find places to live in the whole area because everybody has similar ordinances. Mr. Nelson is the first person who wasn't able to find another place to live when he was notified that he was living in violation of the ordinance.
Let me ask you this, because this has been, what happens if a sex offender is lawfully living somewhere and another offender moves within 6,500 feet under that exception that allows offenders to move into the residence of a family member who's been living there for at least 2 years? Does the first offender have to move, or the second one, or can they both stay? What's the situation with that?
I think there's a hyper-technical reading of the statute that would require the first person to move. I don't think that was the intent. And under the idea that statutes are to be interpreted so as to preserve their constitutionality, I think that person would be allowed to stay. And it's never happened.
If we assumed that every house in the town was vacant and available for purchase, how many sex offenders could the town accommodate under this ordinance?
I don't know how. I don't know how many. I haven't done that, and that's the factual record that went on in summary judgment was not factually rich regarding all the permutations. We did the facts as to currently what was available, but it was not looked at that closely.
But I assume that a sex offender could live just outside the border of Paris and live just a few feet from a daycare facility that is on the Paris side of that border. And I was wondering what you thought, what effect that would have on the rational basis for the ordinance.
Yeah, I mean, I guess that's one of the issues with the fact that you've got multiple municipalities. One municipality can't control everything, so you might have an instance where you can't tell somebody you can't live right across the border, even though it's near a school where your kids are going to be going to school. And then, the whole idea with that is, we're not looking at the perfect law. It doesn't violate due process because it's not perfect, but there's a rational relationship.
And is protection of children the only stated rationale for the ordinance? In other words, did the town ever have any rationale that connected sex offenders whose victims were adults to the threat to children?
If you look at the stated purpose in the ordinance itself, children, protecting children, I believe, is the only stated purpose. Under the idea that we can come up with post hoc rationalizations to preserve the constitutionality of the law. Quite frankly, I considered other rationales behind that weren't listed in the statute. So it does. Dr. Savard had testimony that would suggest it would protect adults from being sexually molested, and it would have other effects. I mean, one thing that I argued, and I think it's a little bit in the materials. It was one of the 4 things that were read and relied on. There's an idea of fairness in clustering, right? It's not fair for one if you live near the Bristol Motel or the Oasis to have all of these dangerous people. Now that's a legislative fact that there is a danger of recidivism. We got to take that as a given. It's really not fair to have all of those clustered in certain areas. So one part of society is bearing the brunt of that danger. So the anti-clustering will help spread that out to spread the risk. And also, you don't get these hot zones, and the idea, it goes with what Dr. Savard was saying as to, like-minded people gathering together might be more inclined to commit crimes. So that's another.
But that's what the empirical evidence has been showing. And although, of course, it's true legislatures don't need to rely on empirical evidence when they legislate. Can they ignore empirical evidence that demonstrates that their legislation doesn't have the effect that the legislation was drafted to have?
I think it goes too far to say that this has been proven. And I think a key thing out here, and it got me when John Holloway, the chairman, was testifying, they're faced with the fact that 70% of these offenses go unreported, up to 70%. Different studies have different numbers. So we really don't know. There could be several sex offenses against children every year, and we don't know. We could have a law that does a good job of reducing the amount, and we might never know. Given the fact that this is such a horrible thing to happen even once, and faced with this lack of data, a legislative body is entitled to be cautious and to say, you know what, we just want to make sure. So I don't think it's been proven that they never work. I think it's impossible to prove. And as this court has pointed out, it's not the job of the courts to sift through the most recent social science data to figure out what is the best law. I think the line drawing is a problem. I don't know. Are you going to tell us that you can have a 3,000 foot? You have to keep a certain amount open. That's for legislatures. And I think here it hasn't reached the point in its effects and its probable effects that it says, you know what? The town is not trying to protect its children. It's trying to punish people because of what they did in the past. That just doesn't appear from this record. Thank you.
Well, many programs, of course, house sex offenders together. Evidence demonstrates that giving sex offenders in putting them in more stable housing opportunities leads to less recidivism. Housing sex offenders together makes it easier for those who want to keep an eye on them. And our current understanding is that sex offenders are not more likely to recidivate than people convicted of committing any other crimes. So is that next, where anyone who, has served their time, encompassed to live in Paris? Well, is that the next step for you?
I would just point out, I'm sorry,
Yeah.
I talked over you.
No, I talked over you.
I would just point out that those studies that say that there is actually a beneficial effect to group homes, those are people that are under the active supervision of the Department of Corrections. And in that aspect, they found it was beneficial. The town doesn't have those resources, and we're not doing parole. We're not actively looking at every aspect of the lives. So we just want to protect them through the zoning. But I'm sorry, I forgot what the last part of your...
Chief, could I ask one more question? I'm sorry, Judge Rovner, are you done? Was there another question?
I just am. No other locality has created such an ordinance. So of course, we have no case law supporting the conclusion that you have put forward.
And just in response to that, my first point was going to be, I think it's a legislative fact. The United States Supreme Court has said that this is a high risk of recidivism, and these are rational measures in general. I think municipalities should be entitled to rely upon that in setting laws. And again, I forgot the second point.
Mr. Well, going back to what you said about clustering, we read the statute and we have to take the legislature for what it says, or the town for what it says in the statute, which is the goal of the statute is to provide better protection for children by minimizing immediate access and proximity to children. Can you point to me to where in the record does anyone from the town tie the requirement that sex offenders not live one another to that purpose, the purpose of protecting children as stated in the statute? Because I looked through Chairman Holloway's deposition, I looked through the record, and I can't find any place where anyone from the town said that the reason why they needed the proximity to other sex offenders provision was to safeguard and protect children.
I think there is something in the record, in the depositions, about a fear that these motels where people can travel and have their kids, that with clustering.
Do you remember where it was? Because I wasn't able to find it.
I don't know if it got into the proposed facts, but I remember after the deposition thinking, I'm going to think twice about going to motels. So there was something there about the idea that it would be dangerous for children who are traveling with their parents to go to hotels if they were full of convicted sex offenders. And I'm sorry, I cannot remember. It might have been the clerk. I can't remember exactly whose testimony that was.
Okay, thank you.
Thank you.
But may I just ask? I'm sorry, but I know I'm obsessed with this number 13. Would the record tell us if all 13 were there at once, or if they sort of floated through, or?
I don't know if the record will tell you. I can remember I got that number in putting together responses to discovery, identifying sex offenders that have lived in the town. I don't believe they were all there at once. And it's a matter of public record. Actually, I don't know if you could track. I mean, I could find out where they are now by looking them up because they're registered sex offenders, so we could find out where they are. My recollection is that many of them moved into neighboring municipalities. They sort of, people view that whole area as sort of a metropolitan area and then move freely, among them. I think that's what happened to most of them.
Okay, thank you so much.
Thank you.
All right, thank you. Ms. Nicholas.
Thank you. I want to address what Council said regarding the appeals board. I think it's extremely problematic to argue that towns are operating as kingdoms that can decide who can live there and who can't. As was pointed out, there are extremely subjective factors here that have almost nothing to do with risk, and that's exactly what happened to Mr. Nelson, is that the town decided, well, he could go somewhere else. He had the wherewithal to afford another residence, and therefore we're not going to let him live in our town. Pardon. And it's simply that kind of power can't be put in the hands of town boards. This is not an individualized risk assessment of the type that was cited favorably by the Eighth Circuit in Weems. This is simply giving discretion to local officials to decide who can live there.
As a matter of ex post facto law?
Pardon?
Are you making a point about ex post facto law or some other source of law for this rule you're proposing about municipal officials categorically not having that discretion?
Well, certainly, I mean,
There's lots of zoning codes that dictate where people can live and where they can't live.
where people can live, but keeping people out of a whole town based on local officials' analysis of whether they can afford to live somewhere else seems to be giving those officials the ability to impose unconstitutional restrictions.
Except that overlooks that there's 41% of the housing stock in Paris that remains available to your client.
Well, I think as a practical reality, 41% is not available. The district court correctly pointed out that there were some parts of the town, and 41% was the figure that was there, but there is a high rate of ownership in this town. So these properties, even if affordable, were not available for purchase, and the town has made clear that its purpose in enacting this ordinance was to target the only rental properties that are in the town. And I guess I just also want to point out that this isn't a generally applicable zoning law. This isn't saying no long-term rentals in the hotels. It's no registrants.
Understood, but you made a very categorical statement about what the town can and can't do, and I don't know the source of law supporting that statement.
I apologize.
Is it as a matter of ex post facto law, a matter of due process law, some other source of law?
Well, yes. I mean, I think that it would implicate both. One, we have an ordinance that is so excessive in relation to the non-punitive purposes that have been articulated by the town that we can't have the town just enforcing that at their sole discretion.
But that's a very low bar as the Supreme Court has defined it. It's not like narrow tailoring for purposes of tiers of scrutiny for heightened review in First Amendment cases, for example. It's rational basis review, basically.
Well, I want to push back on that because, well, the court did say you don't have to have a perfect fit and you don't have to choose the least restrictive alternative. You do have to have restrictions that are reasonable in light of their non-punitive objective. Now, that is a little open-ended, and I will admit that the courts have not been completely clear about what that means, but it is something more than rational basis review. Otherwise, that factor wouldn't exist. It would just be, is it rationally related to a non-punitive purpose? And that would end the inquiry. But there is that other factor in there that looks at the excessiveness and that has to be given some force.
But it's just basically a test for sham rationales, right?
I disagree with that. I think
That's what the Supreme Court, how the Supreme Court characterized it.
That's the fourth factor, whether it has a rational relation to a non-punitive purpose. And then once you get over that and show it's not a sham, then you have to look a little bit more closely at whether it is excessive in relation to those purposes. So I see I'm out of time, so for these reasons, we'll ask that you reverse the district court.
Thank you very much. Our thanks to both counsel. The case is taken under advisement, and the court will take a 10-minute recess before we call the next case. right, thank you, everyone. Our third case this morning is Jessica Biggs versus the Chicago Board of Education.
Good morning, Your Honor. May it please the court. This case involves an occupational liberty interest claim by Ms. Biggs against the Chicago Board of Education. I think it's important to note at first that the occupational liberty interest claim is a quintessential case in many respects. The quintessential case of an occupational liberty interest claim is that situation where a government blacklist effectively precludes an individual from their desired occupation. Now, here, this does involve a limited blacklist, the D&H designation, but it also involves statements that were made that stigmatized Ms. Biggs publicly and enhanced the effect of both that blacklist and the circumstances and statements that were made surrounding her termination.
Counsel, one of the facts that you point to support the notion that the board's actions excluded Ms. Biggs from her profession or her occupation is the fact that she searched for principal jobs outside of Chicago in the summer of 2018 and found none. Well, if none was available, how does that support an argument that the board's actions acted to exclude her from those jobs?
Well, I think that her occupation, the scope of what we're talking about here isn't just the principals, and we're not limiting it to that. It's administrators of any kind in education. To the point that we raised...
Okay, but again, you said she looked for those types of jobs outside of Chicago in the summer of 2018, but none were available because they were all filled for the upcoming fall year. And so I'm still trying to understand how that supports the notion that the board's actions were what excluded her from those occupations.
I think to the extent that we cited in the brief, it was in response to the board's argument, where they say that she didn't apply for any principal positions. And our response is that there weren't any to apply for. This isn't a situation like Black Seal Coding, where there's an allegation that they were excluded from any bids that the city had to offer. There were bids out there that they could have bid on these projects and tried to get these projects, and they just didn't do that. This isn't that case. This is a case where as far as principal positions go, there weren't any available. And
Well,
so
just
the fact
for the short period of time that she was looking, there weren't any available. That's a very short measure of this supposed stigmatizing effect of the D&H designation and the other public comments that you're challenging here.
I agree, but it's not the only, that is a limited period of time. After that, we filed this lawsuit, and she's continued to look, but that isn't the only effort that she made in order to find a job in administration. Although that period of time was brief, where she was actually looking for principal positions, because after the start of the school year, the presumption was that there just aren't going to be very many open administrative positions, including principal positions at that point.
The disclosure by the board was twofold. It disclosed that Ms. Biggs failed to follow policy, which your client agrees with. And according to Ms. Biggs, the board also disclosed that she lacked integrity. But how do we know whether she had trouble getting another job because of the revelation that she failed to follow policy, or because of the disclosure that she lacked integrity? It is possible other schools do not want to hire a principal who does not read and follow policies, right?
I agree with Your Honor that, I apologize for that.
No, I apologize. Go ahead.
I agree with Your Honor that had the statements the board made simply been that she didn't comply with the policies at the time, either for attendance or transportation, there wouldn't be stigma here, or at least the stigma wouldn't rise to the level of a constitutional injury. But that's not exactly what they said. What the title of the memo was, and what was said in both the statements that were reported in the WBEZ article, which recounted the first meeting, and other statements made by the OIG, and statements that were made in the second meeting where they read the OIG executive memo, those statements went even further, and they said that she was actively falsifying attendance data. The OIG specifically related it to previous widespread instances where there was widespread deliberate attendance fraud. And that is different. That is challenging someone's integrity, which they did. They specifically referenced her integrity. And it's that injury that we believe, well, we've shown with instances when she applied for the Learned Charter Network, that it foreclosed her from her occupational liberty, or from her occupation.
So the position that she applied for at the Learned Charter Network was Director of Operations, right? And I think for the Academy group, she applied for Assistant Director position. Doesn't seem to be much in the record as to what exactly those positions entailed, what their duties were, what sort of qualifications were needed, whether she needed a principal's certificate to get those positions. Can you provide some of those details to me? What does a Director of Operations at the Learned Charter Network, what were the responsibilities of that position?
I don't have the full list of what that responsibility entailed, but I do know that for the Academy group, I think as far as the qualifications go, that it is in the record that someone with lesser qualifications ultimately got the job.
Well, I guess that's not my question. My question is, I'm trying to figure out why you believe the Director of Operations and the Assistant Director position would fall within school administration as you have defined her occupation.
Well, my understanding is that Learned Charter Network is a network of charter schools both in Chicago and elsewhere in the nation. And as a Director of Operations, she would be functioning as an executive in the operation of those schools. It's essentially like a superintendent for a large district, is my understanding.
So she wouldn't be operating for a particular school or a particular locale, it would be for the entire network.
My understanding is that it was a job with the Learned Charter Network in general, not with a specific charter school in Chicago.
And do you know whether someone who qualified for that position needed to have school administrator training, such as like a principal certificate or something like that?
I don't know whether or not certification was required, but absolutely it is. Working as a school administrator, being Director of Operations, where you're overseeing numerous other administrators, most certainly would require the level of experience that Ms. Biggs had and other administrators have. It's an education administration position.
And what about I'm sorry.
Go ahead, please.
Assistant Director position? What did that entail?
I believe it's for the Academy group. It is also a school administration position, although assistant directors, like assistant principals, often have very ad hoc responsibilities dependent on what the director needs. But in both cases, my understanding is that it is you're administering either a school or a network of schools, and those are the positions that are assisting a director in doing that. And that is reflected by who was ultimately hired for that position, which was a former CPS assistant principal, not a principal. So someone who had no experience previously at the highest level within a school administration.
As to the question of whether Ms. Biggs is still working within her field, is that a question of fact or law?
I think it's a mixed question of fact or law. Well, actually, so I think whether or not her current occupation is educational administration can be considered a question of law. Well, obviously you need facts to support it, but like the details of what she actually does at SWAP. But my understanding is that it is not an administrative position. She is not working as a school administrator. Has no interaction with kids. She's working as a vendor that supports and provides services to schools. She, as the record shows, she tried to apply for a volunteer position at CPS so that she could volunteer in connection with her duties at SWAP, and she's not allowed to do that because of the D&H. She's basically foreclosed from being on CPS property, interacting with any students because of that D&H.
And is there any evidence in the record about who made the decision to release the Inspector General's report and why that individual had the authority to do that?
There is some evidence. The emails between Liz Kirby, the Chief Education Officer, McDade, and the CEO, Jackson, all three of those are the only ones who were on that email. That shows the decision, at least that's the only record we have of that decision in paper, And that references discussions with legal and with comms, which is the communications team. But ultimately, it is emails that Jackson is CC'd on, and I think the reasonable inference is that she took part in those meetings that are referenced in those emails. And that is where the decision to release this was made.
But that was only after your client sent a detailed email to 100 stakeholders or thereabouts, defending herself, basically, and in advance of the first explanatory meeting that was called to explain the transition in leadership.
That's correct. And we've addressed, I think, the unclean hands argument or this self-publication argument based on Olivieri. That is different from Olivieri, where Olivieri, there was no evidence that that the city in that case had published anything about the results or any details. They didn't even say there was an investigation. The idea was that he would have to, I guess, supposed that it would ultimately be inferred or found out if he applied anywhere else. That's not the case here. When they called that meeting, before she sent that letter to the stakeholders, they specifically referenced that this was the result of findings of improper attendance practices at Burke. It was listed in the letter that went out to the parents.
Right, but she's admitted improper attendance factors, so there's no stigma associated with that when she's admitted that's what she did, and that on its face isn't really stigmatizing.
Right. I think it is, but I agree that it doesn't rise to the level of necessarily the impropriety that we're talking about. I think that it's in the beginning when they sent that letter, they made it very clear that the focus and the reason of her termination and what was going to be discussed at that meeting was the OIG report and what the OIG found. And during that meeting, they referenced that it was about integrity, that they identified these improper attendance practices at Burke, and took it even further by, again, saying that this was about the integrity, or about her integrity, this termination was. So I think that she didn't necessarily raise this issue of whether or not they were accusing her of falsification. It was necessary, and we submit inevitable, that they would disclose that because of the response that was at the meeting where the public demanded it. And in that first meeting, they made the promise that they would ultimately release the OIG report so that the public could see that the findings, they believed, which they argued were true. Ms. Biggs never got to publicly rebut that. And that's essentially why we're here today.
Thank you.
Thank you.
Mr. Doyle.
Good morning. May it please the court, I'm Thomas Doyle on behalf of the Board of Education of the City of Chicago. A couple of the questions struck me, and they struck me as going to what I regard as one of the key issues in this case, which is the limited time period and the limited scope of Ms. Biggs' job hunting to be a principal. One of the key pieces, of her self-defined field of school administrator. Clearly, a principal is a school administrator. Recall the timeline here. It's June 29th that we fired her. There are 2 meetings that she has alleged that were a problem, July 6th and July 9th and July 25th. She sued on September 10th of 2018, alleging just weeks after she had been fired that it was essentially, she was alleging that she had been denied her occupational liberty interest. What that requires, that kind of claim requires under the law of this circuit, she must prove that it was virtually impossible for her to gain work in her chosen field. The limited nature of her search as of the time she sued, that September 10th date, she clearly couldn't make that test. She stopped looking altogether for principal jobs by November of 2018, also an undisputed fact on this record. The limited nature of her search and the limited time of her search means that Ms. Biggs cannot satisfy the virtual impossibility test. You recall from the Wroblewski case, the formulation of virtually impossible is, did she suffer a protracted interruption, or let me get the phrase correct. It is did she suffer a protracted interruption or a permanent exclusion? And that's certainly not shown on this record based on the limited nature of the search that she did. I'd also like to focus on one of the things that we spent some time on in the briefing that went unresponded to in the reply brief. We spent some time at pages 34 to 38 of our brief discussing how what the board said was not false. And we discussed the two areas that have been tossed around in this case as the areas of false statement of fact. One of them being this falsification issue, the other being integrity. We spent some time in the brief going through how there was ample basis for the board to say what it is that it said. That goes unresponded to. You look at the reply brief deals with this issue very briefly at pages 23 to 24 of the reply brief and just doesn't answer the evidentiary record. One of the things my colleague just told you is that the board said via the Inspector General report that Ms. Biggs had falsified records. That sentence does not appear in the Inspector General report. Falsification is on the title of that report. You can see the board's Inspector General report. It is in the record at ECF 101-6. The description that my colleague gave of what is in there that is a direct accusation, he says, as to what Ms. Biggs did simply doesn't appear in that document. Rather, what that document does is it shows the board had policies. Ms. Biggs was responsible for knowing those policies. That fact is undisputed. She did not know those policies. That fact is undisputed. And her team at Burke School did not follow those policies. That fact is also undisputed. That is certainly true with the attendance documents, and that is also true with the student transportation policy. On this record, the board didn't say anything false. And on this record, Ms. Biggs cannot show that it was virtually impossible for her to work in her chosen field. I'm happy to discuss anything else your honors have on your plate or any other questions you have for me. But for the reasons that I've discussed today and the reasons covered in the briefs, we'd ask you to affirm the district court.
Counsel, do you think that the district court's definition of what Ms. Biggs' occupation was too expansive?
I don't. And the reason I don't is because under the cases, they talk about, have you been excluded from your field of work? There's ample cases that say you don't have a right to a specific job. She's working in the field of education right now. She's doing consulting work at a school in Berwick.
So if she had a job as a private tutor, would you say that she was working in the field of education?
I would.
What if she was writing a book about education?
That one might be harder for me.
What if she was a radio commentator on educational policies?
That one strikes me as too far. But I think if she's working with schools, she's working in the field of education.
I do have a question. Suppose an employee knows there is something troubling in her prior employment file. So she prophylactically reveals it in interviews. Would that mean she can never file a deprivation of occupational liberty claim because she, and not the employer, revealed the information herself?
There are ample cases that say an occupational liberty interest claim requires that the employer disclosed the information that made its way to the prospective employers. If the facts that you're imagining, Judge, if on those facts the employer was always, the employer that fired her, for us, for example, the board, if the board had always been completely silent, there cannot be an occupational liberty interest claim against us in that circumstance, to answer your hypothetical.
But doesn't that put employees in a bind? In other words, to protect a future legal claim, they can't disclose prior issues themselves, but they have to wait for the employer to disclose it in a reference check, at which point it will look as though they were hiding the information. Do you see my...
I do. I guess I am not as sympathetic that all of the circumstances that you're discussing ought to rise to the level of a constitutional due process deprivation. There doesn't strike me as a due process problem in the situation you've described, even if it is not ideal for an employee.
You know, it's really interesting because the way I saw it, the elements of deprivation of occupational liberty require public disclosure, but does not seem to require that the public disclosure is the only disclosure or even the first disclosure. So why do you think it matters?
That's a very good question, and I think it matters for a couple of reasons. One is I think it matters because it helps explain what it is that happened here. The board gave a very limited letter. When the board sent a letter to the community that said Ms. Biggs has been replaced as the principal after an inspector general investigation, there will be a meeting July 9th. That's all the board said. Ms. Biggs then starts emailing stakeholders at the school, trumpeting in this blast and extended self-disclosing email that the board said this, and the board is saying this, and the board is saying this. The board had said nothing of the kind as of July 2nd, as of July 3rd, as of July 6th, which were the dates of those emails. By the time the July 9th community meeting call comes around, the community is saying, what is this Inspector General report? Because Ms. Biggs has started a brush fire. By the time the July 25th meeting comes around, the board is facing calls from the community. These are undisputed facts. Calls from the community that we need to see the Inspector General report, and then the board releases it. All of it goes to explain what it is that happened here. And for the purposes of Monell, it certainly goes to whether the board acted with deliberate indifference to her rights. Because the board was careful with what we said, and then Ms. Biggs started an argument, and when we responded, she sued us.
And just one last thing, the same question that I asked Mr. Fink as to the question of whether she's still working within her field. Do you think it's a question of fact or of law, or do you think it's mixed, as he does?
I guess I had not thought about that before you asked that this morning. I think that's probably a question of fact, whether her current job at Southwest Organizing Project ought to be characterized as in the field of education or not in the field of education. And I say that because if I were a judge trying to sit through and weigh that question, I wouldn't look at cases. I would ask about the events, which suggests to me it's a question of fact.
Does it matter?
I don't know that it matters in this case.
I mean, not the question of law, question of fact dichotomy, but does the characterization of her current job matter to the ultimate question about whether it's virtually impossible for her to find a job in her field?
It matters on the very last piece of that sentence that you just said, which is what is her chosen field as to which it is virtually impossible.
But even if the answer to the question about whether her current job is in her chosen field is no,
yes,
does it matter?
I'm following your question. No, I don't think it matters in this case because her search is so limited and so short.
Thank you.
Okay.
If you have no further questions, thank you, Your Honors. We'd ask that you affirm the district court.
Thank you. Mr. Fink. Oh, has his time expired?
My time's expired.
You can have a couple of minutes to rebut.
Thank you.
Had a lot of questions for you.
First of all, I just want to respond to one point. The idea this is a self-defined field, I don't think is accurate. Educational administrators is a very well-defined field. There are certifications, licenses that are required. You know, she can't look outside the state of Illinois if she's not licensed, you know, as an education administrator in most jurisdictions.
It's a big state.
It is a big state. It's also a big school district. It's the 4th largest in the country. And so the fact that
She didn't
prohibited
look
from
very
being-
far.
Okay, but she did look. And that's a question. If that is a question of fact, we
And
submitted
she
something
didn't
that-
look very long.
She didn't look very long, but she did look. And I think the effect of the statements also, I mean, as this court has said, that whether or not she was stigmatized is a matter of degree. And that's the distinction between whether or not it's actually defamation or whether we're talking about stigmatization and the stigmatization test in this case. And to that, you can look at the actual statements that were made in addition to her efforts to show that those statements precluded her from or actually caused this harm. She did that here. She applied to positions that she was qualified for. Those educators, once they looked her up, Googled her name, the third hit was this article, which accused her of fraud, and in which the board accused her of fraud, board employees accused her of fraud. And that itself, we submit, is a question of fact for the jury as to whether or not that made it virtually impossible for her to find education in her or employment as an educational professional or as an education administrator. All the cases which the board has cited in their brief on that point all involve cases where someone didn't look at all because they feared that they would be self-publishing in that case, and there was no real publication. It's a publication issue, really, on behalf of the municipality. Here, the municipality did publish it numerous times and published it publicly several times. Just really quickly, regarding the issue of whether or not we've identified these statements as false, or which statements that were false, we, in our reply, thoroughly addressed which statements we're talking about here. And in our briefing, both in our reply and in summary judgment, in pages, I believe, is 9 through 19 of the summary judgment brief for the plaintiffs, we went into great detail as to why those statements in the OIG report specifically were false, and in some cases admittedly false by OIG investigators, the ones who actually prepared the report. They admitted that these statements were taken out of context in the executive memo, which was the summary of the report that was provided to everyone else. And so on that issue, we just feel there isn't too much to say that hasn't already been said, and it wasn't addressed by the court at all in its decision on summary judgment. And so we decided to focus on the issues which this court is focused on today.
All right, thank you. Thanks to both counsel. The case is taken under advisement. And our next case for argument this morning is Thomas Russell versus Zimmer Incorporated. Mr. Malley.
Good morning, Your Honors. May it please the Court, my name is John Maley, privileged to represent Dr. Russell and his fellow inventors in this matter and be before you on this appeal. Respectfully, the decision below should be reversed, dismissing the First Amendment complaint that sets forth a breach of contract claim against the defendant. This is a case of these inventors being denied the opportunity to even start discovery to further build their case against Zimmer. But certainly at the 12b6 stage, under this court's precedents and the Supreme Court's precedents, they have stated a plausible breach of contract claim. And how do we know that, Your Honors? Well, from the detailed complaint, they set forth the history, that they negotiated a reduced purchase price for the innovative products that they had developed, in part for a multi-year through 2033 earn-out stream of income, very common setup in acquiring intellectual property. And they did it not with just a wish that it might happen, but with a contractual standard that was set forth verbatim in their complaint for commercial reasonable standards.
Right. Now, according to the language of the contract, commercially reasonable efforts are those that Zimmer would apply in the ordinary course of business while satisfying a comparable obligation. So don't you have to show what Zimmer does with comparable products?
Yes, Your Honor, that is exactly correct, that this contract has that language, and we have pleaded that that standard has been violated and given examples of actions, for instance, stopping production, not meeting purchase orders. Those are examples as pleaded of what Zimmer would be doing with comparable products. Now, obviously in discovery, there'd be more in-depth analysis of that, but that is a plausible, more than threadbare claim to match this court standards and the Twombly and Iqbal standards to satisfy the Rule 8 and the Rule 12b6 standards.
I think the problem is not a lack of detail, it's the lack of connection to the contractual provision in question, which establishes the measure for commercially reasonable efforts and keys it to Zimmer and what is ordinary and reasonable within its own operations, not some objective industry standard. This would suffice for an objective industry standard if the contract in question required commercially reasonable efforts measured by that standard, but it doesn't.
Yes, Your Honor, it does set forth, the complaint sets forth that precise standard, to not run away from that inward-looking Zimmer-focused standard. Remember here that Dr. Russell, 37-year veteran in this area of innovative surgical techniques and products, Zimmer's a known quantity in the field, and that he's involved and has patented a number of products. And so he is the basis for these allegations that these types of steps are not what Zimmer would take under the contractual standards. And also this court's precedent requires that we have to look at what would these plaintiffs have in terms of available information at the time of pleading, that commensurate information. And this is certainly sufficient for that standard that would allow then further discovery for, well, what is it? For instance, we don't see from any of the facts that are pleaded that Zimmer said, for instance, and remember this is 2016 to 2019, oh, we had a supply chain issue. Oh, the FDA revoked the approval that these individuals had obtained through their hard work and ingenuity. We don't have yet a pandemic issue that informed the issue. Those are the types of things that would be potential excuses for not doing this. Recall that the statute, or the commercial reasonable standard that they agreed to is each quarter they shall use commercial reasonableness based upon what they do with their other products to sell this product.
Well, it's even more narrow than that. It's based on what they do with a comparable product or technology, similar to the earn-out products in terms of commercial potential, development stage, and product life. In determining whether that standard has been met, the entire business, financial, commercial, scientific, clinical, and regulatory context shall be considered.
Yes.
That leaves a lot of business discretion to Zimmer. This isn't a very valuable clause at bottom because it invests so much discretionary room for movement in the buyer.
But respectfully, Your Honor, it still is a standard. It is not, they could have negotiated and paid more for it. We have total discretion. It's a commercially reasonable standard based on how they do their business otherwise, with, as you've noted. And so, for instance, the examples are, allowing regulatory approval to expire, dismantling equipment, failing to meet customer orders, terminating meaningful communication with the vendors, even though they have this obligation all the way through 2033, every single quarter to do these things, and they have stopped.
Mr. Malley,
what do we do with the language that Zimmer shall have the right to operate their business in accordance with their own commercially reasonable discretion? What do we do with that?
Well, we respect it, but it's still a standard and a measure that they have to live up to. And we have pleaded 21 examples of how they did not do that, and discovery should show more. Now, go ahead, Judge.
Mr. Malley, in essence, what you're saying and what the clause says is that Zimmer has to treat us like A, B, and C. Okay. And the problem, I see it, is that there's nothing in the allegations as to how Zimmer treats A, B, and C. And so if your claim is that your client is being treated less favorably than A, B, and C, doesn't the complaint have to at least provide a basis of why we would believe that Zimmer, or how Zimmer was treating A, B, and C, and why your client is being treated less favorably. And the complaint doesn't really do that as far as I can see.
So, Your Honor, two responses to that. First of all, the complaint at paragraph 61 says that the following actions show Zimmer failed to use the efforts right from the standard quoted above expressly, and list those 21 examples. Again, the plaintiffs here are sophisticated trauma surgeons, patent holders, developers of these types of products, and know Zimmer. So it's plausible that what is alleged is based on what they know Zimmer to be doing otherwise. Then we go to discovery, Your Honor. If we look at this court's precedent,
Aren't your clients just guessing as to what they think Zimmer is actually doing with this other products, and then saying, well, that's a standard that we think Zimmer is holding itself in its own other business lines, and it's not doing that there. To me, that seems more speculative than plausible allegations.
Your Honor, under the precedent, we believe it does meet a plausibility. It's not, is it more probable than not? Is it hypothetical that it could be the case? And then when we look at Olson from this court, that the pleading burden is commensurate with the amount of information available to plaintiffs. If this court is going to shut plaintiffs off from being able to conduct discovery in these kinds of commercially reasonable standard provisions, then it would be a worthless clause, even though it's contractually in there. If we then look at Brooks from this court, if there's a reasonable expectation to discover real evidence supporting the allegations, and these plaintiffs were denied that opportunity, including the opportunity to amend, and I'll turn to that briefly, Your Honors, that going back to Foman versus Davis and, of course, Rule 15A2, that the proper outcome here, if the court were to determine that, yes, there is more required, then leave to amend upon the first dismissal would be appropriate. And the decision that the court made was not that there was undue prejudice, and there would not be undue prejudice from responding to another complaint, either answering it or moving to dismiss. Instead, Her Honor found futility. That is reviewed under Norwin on a de novo basis, on the legal basis of futility. And there's certainly, again, no reason to think that the plaintiffs wouldn't be able to plead more to meet the ABC type of standard that Your Honor has laid out to compare with other companies. Dig further, look at the public information that's available, and make that attempt. They should certainly at least be entitled to that opportunity to leave to amend to put that case before the district court.
But your client did have that opportunity to put that before the district court, and it didn't do so. I mean, it had the opportunity to tell the district court what additional allegations it would consider bringing if it were given the chance, but your client was silent before district court in that regard.
Yeah, respectfully, Your Honor, our clients did what they thought was the right thing to do to trim the claims. There was no objection to the amendment from Zimmer, and they amended, and it went down just to the contract claim. Now that's been dismissed, and under Foman and Rule 15A2, there's been this dismissal. They should have the right to try to get a proper pleading that would pass muster, and if allowed amendment, would do so, respectfully, Your Honors. I see my time has expired. Thank you.
Thank you. Mr. Brown.
Good morning, Your Honors. May it please the Court, Troy Brown for Appellee Zimmer, Inc. I'll start with a few of the questions that Your Honors asked of my colleague, which is one benefit that Zimmer has in connection with both the original complaint and the first amended complaint is the fact that we don't have to guess about, and this panel and the district court didn't have to guess about the context within which these two sophisticated parties decided to come to the table to negotiate with sophisticated counsel a merger and acquisition transaction, because plaintiffs pleaded it in their complaint. They pleaded that they accepted a $17 million cash payment for a business that they have alleged was failing. They themselves, despite the sophistication that my colleague and in the briefing has talked about with these inventors and developers of this Enforce product, had failed sales. They sold the business and they negotiated at the bargaining table the provision they were able to secure. Like any parties, particularly under Indiana law that looks at the sanctity of the express terms of a contract when sophisticated parties reach a reasoned bargain. And that is a completely unqualified, no guarantee, fully disclaimed, inward-facing, commercially reasonable efforts provision. And Judge Sykes, you actually asked counsel whether or not, had this been an outward-facing provision, like what we've briefed, inward versus outward, which is a more seller-favorable provision because it has objectivity looking outside the market. What might comparable buyers have done in this circumstance? And I think your comment, Your Honor, was then it might have passed muster. And I would suggest that under Norvana, that's a perfect case from Delaware Chancery Court to look at, or even outward-facing seller-favorable provisions, like what was at issue in a medical device case, Norvana, a product for cerebral aneurysms. The court looked at that outward-facing and looked at a plausibility standard that, again, in Delaware state pleading is more favorable for plaintiffs, a lower standard, reasonable conceivability, which the Delaware Supreme Court has said is actually lower than the Twombly standard in federal court. It gives the plaintiffs an easier burden. And the court said even there, with a seller-friendly outward-facing provision, plaintiffs couldn't meet their burden because what they didn't do, to both Your Honor's questions to my colleague, is tether somehow, not just pronouncements of actions or inactions, as paragraph 61 of the First Amended Complaint speaks to, occurred in a vacuum. But as Judge Springman looked at and analyzed comprehensively, what they haven't been able to do twice, and what the judge found would be futile in trying to do a third time, despite opportunities previously, is tether factually to meet the plausibility standard. How an action or an inaction looked at in a vacuum could possibly constitute a breach of this inward-facing, extremely buyer-friendly Zimmer introspective provision that doesn't just look necessarily at what Zimmer might have done vis-a-vis product X that it might have acquired in 2015 or product Y that it might have acquired in 2020. What it looks at, as the language says very comprehensively in 205A and E, is what would Zimmer do in looking at its entire business and financial portfolio and needs at a particular time, and I'm paraphrasing obviously, and look inward. And it didn't stop there, as Judge Lee, Your Honor, commented, which is it also said, we are expressly disclaiming that either we may do things the way your learned inventor sellers might have done things in the past decades when they were inventing these products. We might do things differently that guarantees no potential earnout in the future because you've told us, and you've now told this court and the underlying district court, that this business was struggling and on its way to bankruptcy. The reason parties sometimes agree to earnout provisions, as Your Honors know, is because there is a disconnect at the negotiating table in valuing the assets sold or the stock sold. There was a disconnect.
Mr. Brown, forgive me, but if Zimmer had amended its complaint to say the following, would it have stated a valid claim? Zimmer has used a far greater level of effort, expertise, and resources to fulfill its obligations with a comparable product to which it has comparable obligations than it has used with respect to the earnout products. Would that be then a valid claim?
So I'll answer that, Your Honor, thank you, two ways. First, I'll answer it not entirely directly, and then I will answer it directly. The not entirely directly answer is it would depend on the overarching complaint, if there were a second amended complaint, and whether or not that statement taken in isolation and perhaps not tied to a particular product and particularly plausible factual tethering would or would not overcome the pleading hurdle. I'll answer it more directly, which is I don't believe that plaintiffs can make that allegation, and if they were able to, this case, as Judge Springman observed in her futility and prejudice analysis, was 2.5 years old. This was an original complaint filed intentionally in the wrong district court that had to be moved to transfer from the Western District of Tennessee to the court that the parties agreed it would be in the Northern District of Indiana. There was an original complaint that was then pared back after we filed a motion to dismiss, identifying all of the problems with both the contract and the non-contract and fraudulent inducement claims. And then an amended complaint was filed. And in response to the challenges to the amended complaint, as Judge Springman identified in her futility and prejudice analysis, what plaintiffs didn't do again is say, Your Honor, here's how we would tether factually to a breach of Section 2.05 that might meet plausibility under this provision. So, Your Honor, had they pleaded that with specific facts as to a specific acquired product and then tied it to how that allegedly breaches Section 205, perhaps I would have had a harder fight at the district court and a harder ability here.
How is a seller in this situation supposed to acquire that information necessary to plead to the standard that you're articulating?
Yes, and
with one of these inward-facing clauses?
It's an excellent question, Judge Sykes, and I've thought about that because it's the obvious question that one would get. What I think plaintiffs have suggested and appellants have suggested is, well, one could never overcome a standard as a seller with an inward-facing provision because, absent some other information, how, without a fishing expedition into discovery, could we tether conduct to breach of this inward-facing? And the answer is threefold, I believe. And two of them is not a particularly pleasant answer for the sellers of the world, but it is the sanctity of contract in Indiana that requires it. And it is negotiate a different provision. If you want to be protected in potential litigation post-closing such that you have the ability, and there are a variety of techniques that sophisticated deal counsel, like what these sophisticated sellers had, to protect themselves. Like post-closing audit and information rights that sellers, even when they have inward-facing provisions like this, negotiate for themselves. Hey, this potential earnout goes out to 2033. Maybe as sellers, even if you have little bargaining power because you're about to go bankrupt, should negotiate for themselves protections. Like every quarter, we're going to solicit information. And part of that information could be, how is Zimmer treating similar products, whether they are fixation products like the Enforce fixation system that was acquired here, or other hip, knee, or orthopedic products. But they didn't do that. They could also have secured for themselves, from the due diligence process, some information about how Zimmer had treated pre-closing acquisitions. They had due diligence, and these parties actually, as is pleaded, had a history together. These were not strangers coming to the table to try to acquire a new product. The parties had worked together in the distribution field. These inventors knew Zimmer. At the time, Zimmer knew Zimmer Biomet, the merged company ultimately. And so had they wanted to protect themselves, they could say, hey, we know you've acquired these 4 other products in the last 10 years. We'd like information to create for ourselves a pre-closing baseline against which we might be able to measure this very Zimmer favorable inward-facing provision. And they didn't ask for that. The other thing, Your Honor, that they could do, as any sophisticated party can, is they can walk away from the deal table and run the business themselves or find a different buyer. If the best they could get is this type of inward-facing provision with no due diligence protections and no post-closing audit and information protections with a section that reads as this one does, then that is the best bargain they were able to draw, and they cannot rewrite through litigation and appeal the provisions in a contract that they agreed to at the bargaining table. I see my time is up.
All right, thank you.
Thank you, Your Honors.
Mr. Maley.
Briefly, Your Honors, first turning to Judge Rovner's question, if the language said, as Her Honor posited, that this effort was not comparable to others, essentially, again, when you go back to paragraph 61, saying pleading that they did not meet the standard and listing those examples, such as letting regulatory approval pass. Zimmer does not do that with others. They're a large, successful global company. Judge Sykes, your question about is this why discovery is needed, essentially, and yes, that aligns with this court's precedent from Olson and Brooks that the burden on pleading is commensurate with the information available to the plaintiffs. And Zimmer and no other company gets to contract that away from a litigant. And lastly, on amendment, for this court's precedent in St. Anthony and other cases, St. Anthony Hospital, the standard is to allow amendment usually at least once after dismissal. That hasn't happened. The futility finding that was made under Norwin is reviewed de novo. And it's hard to say that this would be futile given the allegations that have already been made. Respectfully,
what would you do if granted leave to amend by way of acquiring the necessary information to plead to the standard in the contract?
Yes. Your Honor, we would, with our clients who have knowledge in the industry, we would scour every publicly available product that is out there, and I'd show what they have said publicly about it. They're a publicly traded company, and it would be a very, very lengthy pleading that would leave no question at all that we have matched up these failures, such as they let regulatory approval lapse for our product. They didn't do that for these comparable products.
So there is publicly available information that addresses itself to the
There should be, Your Honor.
terms of the inward-facing.
There should be,
clause.
in some respects, although discovery to line up the comparable products would certainly be helpful, Your Honor.
All right, thank you.
Thank you.
Our thanks to both counsel. The case is taken under advisement. And our last case for argument this morning is United States versus Samuel Caraway. All right, we have Mr. Smith on Zoom. Can you hear me?
Yes, Your Honor, I can.
All right, and Mr. Dean is here in the courtroom. You may proceed.
Thank you. My name is Greg Smith. I represent the appellate Samuel Caraway. May it please the court. The district court in this case sentenced Mr. Caraway to 360 months imprisonment on a charge of conspiracy to distribute cocaine and possess with the intent to distribute cocaine. Part of that sentence was based upon a 2-level enhancement for obstruction of justice under Section 3C 1.1 of the sentencing guidelines. The pre-sentence report stated that Mr. Caraway willfully obstructed or impeded the administration of justice when he ceased contact with the government and its agents following his May 2017 interview and then successfully evaded arrest for approximately 42 months following his indictment. Mr. Caraway objected to that statement in that paragraph in the pre-sentence report. The district court agreed with the pre-sentence report and overruled Mr. Caraway's objection, stating that this sort of conduct, according to the district court, fell in the category of calculated evasion and not panicked or instinctive flight. The court further said he successfully evaded law enforcement. So that is what the appeal is about, that 2-level enhancement for obstruction of justice. Mr. Caraway's position here, as stated in my brief, is that the government failed to show any deliberate act or conduct on the part of Mr. Caraway that it was indicative of willful or calculated evasion. There was no deliberate act. There was no conduct.
So is it your contention that one needs to physically flee in order to evade arrest? In other words, hiding in a city of 2 million can't be evasion?
Well, Your Honor, I would say that the cases certainly all indicate, or they show flight because that was the particular conduct in those cases. Mm-hmm. Simply being in a city and not being found, I don't believe is actual evidence of evasion. I do believe there's a difference between being found or not being found, but if we're going to say that there was some deliberate act or his evasion was calculated, there would need to be more than just simply the fact that they didn't find him. I don't believe there's an obligation to turn oneself in. I'm not saying that that was the case here, but But I think the Enuribe, or I'm pronouncing the name wrong, Enuribe, states that there's a difference between not making it easier for the police to arrest you and making it much harder. One of the cases that we both cite, the government and Mr. Carraway, is that Porter case. And I think Porter starts out just like Mr. Carraway's case. There's a meeting with law enforcement. There's some admissions of conduct. There's an attorney who's alleged to have been involved. There's information that an indictment is pending or coming soon. But where we draw a distinction between Porter is that in Porter, that defendant changed his identity, had fake documents, birth certificate, social security card. He moved to another state. He moved from Indianapolis to Tennessee. He was found with a book on how to change your identity. And the court found those actions were deliberate. Those actions were calculated and deliberate, but we don't have that here. They talk about at the time of his flight. So, Your Honor, my contention isn't necessarily that there has to be flight, but that's what we see in these cases. My contention rather would be that they still have to show something that he did. What was his conduct here that was evasive? Simply not being found or this delay in time, I don't believe rises to the level of obstruction. Now, one other point that I wanted to make was that the government, with respect to his actual and ultimate arrest down in Texas in July of 2021, it's at that time it's alleged that Mr. Carraway gives 2 false names to police when he's being arrested. And I believe that is more indicative of this panicked or instinctive conduct that the Draves case talks about. Draves talks about the guy who's in handcuffs in a U.S. Postal Service car. He's in handcuffs. They go to arrest somebody else, and he runs out the door, and they catch him 3 houses down. And the court refers to it actually as pathetic. And they refer to it as not some calculated act, some instinctive act, some, again, pathetic, panicked act. And that's what happened, I believe, here. He gives two names that are false to law enforcement. That is not going to work. I mean, it took this trooper a matter of minutes to get him to admit that wasn't his name. And this all happened on roads on the side of the road. And I believe the phrase that they talk about is when one suddenly finds himself in the power of the police, they do things like that. And that is not obstructive, calculated conduct, but more instinctive or panicked conduct.
Now, Mr. Carraway knew during his proffer interview that he was about to be indicted, right?
My understanding is he was told that, yes, Your Honor.
Well, what obligation do you think that would impose on him or anyone in his position?
With respect to remaining in communication with law enforcement and the government, or just remaining in communication with anyone? I'm not sure I know which one you're on.
Well, I mean, even if we assume that his lawyer had never passed along the message, does it really matter? Because he knew that it was coming. And I'm just wondering,
knowing that it's coming, Your Honor, I think is different than doing something to avoid it. And I don't know that we have that affirmative, deliberate act to necessarily avoid that. Being told you're going to be, and let's not forget, he was indicted 2 years after the other defendants in this case. So, I mean, they were all indicted. He proffered in similar time, but they don't indict him for 2 years after the others. So saying that an indictment is coming, I'm not sure what his obligation is then he doesn't have one to turn himself in. Again, I think not making it easier to get caught is different than making it harder. And I just don't see that here. And I believe I had asked for maybe 3 minutes in rebuttal, and I think the clock shows that. So I will stop there and
That's fine.
Thank you, Your Honor.
Mr. Dean.
May it please the court, David Dean on behalf of the United States, the appellee in this matter. I'd like to actually begin my comments by addressing an issue that Mr. Smith did not reach, that being the harmless error issue that is at issue here. While the government is very confident that the district court did not clearly err in finding that Mr. Carraway obstructed justice by evading arrest, that's actually not a question that this court even needs to reach, because the district court made very clear in imposing sentence that its choice of sentence, 360 months, would have been the same even if the obstruction issue had come out the other way. That means that remand, the relief that Mr. Carraway seeks, would be a pointless exercise in this case. And it means that any procedural error that the district court may have made in calculating the guidelines was harmless.
Mr. Dean,
yes.
I'm looking at what the district court said. He said, this would be my sentence even if my rulings on the objections were wrong and the guideline range would be something else. Is that enough? I mean, because if we find he did err on the guideline calculations, then the 360 months would far exceed the guidelines that would apply in that case. And don't we expect district courts to do a little bit more, explain why they're going to impose a sentence that is greater or substantially greater than the guidelines, other than just a flat-out statement, oh, I would have done it anyway?
Yes, Your Honor. And this court just last year in the Asbury case reiterated that there are no magic words. The district court can invoke like a mantra and thus inoculate its sentence. That said, that's really not what the court did here. In Asbury, this court stated that the requirements to effectively inoculate a sentence from any finding of reversible guidelines error are twofold. First, the district court must give specific attention to the contested guideline issue. And second, the district court must explain the parallel result, meaning that it must adequately account for why, if there was an error, it wouldn't result in a different sentence. Now, the first of those two requirements, I believe Mr. Carraway has actually conceded in this case. On page 5 of his reply brief, Mr. Carraway wrote that it concedes that the district court gave attention to the contested guideline issue. So I won't belabor that point any further. But as to the second requirement, I believe that's also satisfied in this case. And the sufficiency of the district court's explanation of its parallel result, I believe, can be seen in this case in at least 3 ways. First, the district court calculated the guideline range that would result even if the obstruction issue had come out the other way. I think that's very important because it enables this court on review to see and know that when the district court said, even if the guidelines came out differently, I would impose the same sentence, it wasn't just flying blind. It knew exactly what that meant and nevertheless persisted in saying 360 months would be my sentence. Secondly, the district court very clearly rooted its sentence in its application and analysis of the 3553A factors. Its analysis of those points was detailed, and the government has addressed it in its brief. I don't want to belabor it here except to highlight one aspect that I think is especially pertinent. And that's where the district court said, in assessing the relevant conduct in this case, it said that the drug quantity and the corresponding value of the drugs was the most that this judge had ever seen in her 8 years on the bench. Then the district court said that Mr. Carraway himself personally was, quote, by far the most culpable of all of the co-defendants and co-conspirators in this case. Then, when imposing sentence, the court said 360 months is the largest sentence I've ever imposed in a drug case, and I've only done that 1 or 2 times previously. But, and again I'm quoting, given the extensive nature of this drug trafficking organization, that is certainly appropriate. So I think you can draw a pretty straight line through those comments that says that the district court was pretty clearly assessing Mr. Carraway's culpability both relative not only to his own co-defendants, but also to all other drug defendants the court had ever encountered, and concluded that a sentence of 360 months, the highest sentence the court had ever imposed, was appropriate in this case. In other words, the court said, this is the largest drug case I've ever had. Mr. Carraway is the most culpable defendant in this case, and therefore a sentence of 360 months is appropriate. And that's completely irrespective and not relying on the guideline range, Your Honor. The final point I would say in terms of the adequacy of this, its explanation for the parallel result is the statement that anything less than 360 months would be insufficient to achieve the goals of sentencing. I simply don't know how the district court can any more clearly say that its its ultimate choice of sentence was not tethered to a specific guideline range. And in fact, Your Honors, I would direct the court to the Alvarez-Carvajal case decided just 2 years ago, in which a virtually identical statement by this exact judge was deemed sufficient to find harmless error under very similar circumstances.
Now, if we suppose that Mr. Carraway's lawyer never gave him the message about the indictment, the surrender date, is it your position, is it the government's position that he had a duty to walk into a police station and surrender himself because he did have the knowledge that he was going to be indicted soon? And on what date do you think that obligation accrued?
Your Honor, I don't believe it's a question of obligation, and I think the Nduribe case suggests that there is no obligation for a defendant who knows that indictment is coming to surrender himself. But I think the relevance of Mr. Carraway's knowledge, which, as Mr. Smith just conceded, at least as of May 2017, Mr. Carraway, at the proper session, Mr. Carraway knew an indictment was imminent. And so, if turning to the merits, Your Honor, I think that in the government's view, this is clearly a case where the standard of review is dispositive. This court said in the Cisneros case that a district court's obstruction finding is reviewed only for clear error, with deference giving to the court's application of the guidelines to the facts. So clear error is the standard, and this court elsewhere has repeatedly said that a clear error is an extremely deferential standard review, which will all that has to be shown is plausibility of all of the evidence. And if you look at the totality of the evidence, Your Honor, I think the district court's account and their thus conclusion that Mr. Carraway was calculatedly evading arrest is certainly a plausible interpretation of the evidence. Here's what we see. Mr. Carraway he certainly knew that indictment was coming, and then he abruptly cuts off all communication, not just with the government, but also with his own attorney, even with his own family members. Then he disappears. He's not found in locations where the government knew he previously had been. He cuts off all communication with his family members, and then, maybe most importantly, he refrains from any traceable commercial activity. Mr. Smith has suggested there's no evidence. I think what really this case is about is the distinction between direct evidence and circumstantial evidence. We don't have direct evidence because we don't, as the district court concluded, he was evading arrest effectively. What we do see is when the law enforcement finally catches up with him on the Texas roadside, he repeatedly lies about who he is. And then when confronted with those lies, he actually admits that the reason he was doing so is because he knew he was wanted. All of those things, I think, certainly mean that the district court's conclusion that he was actively evading arrest was at least plausible. And
forgive me, does the record tell us, do we know if the warrant in this case was his only outstanding warrant?
No, I do know he had at least one other active warrant for a Texas matter. So I would just emphasize that this court need not find that the district court's interpretation of the evidence was the only plausible interpretation, or even that it was the most plausible interpretation of the evidence. It's sufficient to find that it was plausible, and obviously that is a very difficult standard for Mr. Carraway to prevail under. In fact, I would just note that, at least as far as the government is aware, in the 25 years since Draves, when this court first recognized that there could be obstruction of justice based on evasion or flight, this court has never, to the government's knowledge, never reversed a district court's finding of obstruction based on flight or evasion under the clearly erroneous standard. And this certainly shouldn't be the first case to do so. For all of those reasons, the government asks that the judgment and sentence of the district court be affirmed. Thank you.
Thank you. Mr. Smith.
Thank you, Your Honor. I wanted to address the question from Judge Lee to Mr. Dean regarding, do we expect more of the district court? I do agree that Judge Rosenstengel did cover the objection. She covered that, and I believe the record is clear. But that second prong of that test that's in Asbury, it says, did she adequately discuss or explain the parallel result? Well, if that objection had been sustained, the offense level would have dropped from 38 to 36, which would have resulted in a guideline range of 235 to 293 months. And Judge Rosenstengel said, simply stating that guideline range wouldn't meet the sentencing goals, but she didn't go any further. She didn't talk about why 235 to 293 months would not be sufficient to satisfy those purposes of punishment. under 3553A. So I don't believe that it was adequately explained, that parallel result of the lesser sentence. So therefore, I don't believe it's harmless error. Judge Rovner, with respect to another warrant, Mr. Caraway did have a warrant out of the state of Texas at the time of the roadside stop. And when he did say, I have warrants, there was no distinction between whether this warrant in this particular federal case or the state case out of the state of Texas. And then with respect to the plausible interpretation, I appreciate the government's stance on, well, this could be plausible. But again, I still have not seen some affirmative deliberate act on behalf of Mr. Caraway that would suggest he was evading arrest. It's not there. The case law that we have always points to something, whether that's flight, whether it's leaving the country, whether it's moving to another state, whether it's changing your identity, false documents. We don't have any of that. What we have is the U.S. Marshals didn't find him. They say they looked. This avoiding traceable commercial activity, that cannot be enough to say that he obstructed justice. So I know I'm repeating myself a bit, but I'm just responding to the government's contentions. But I would ask that the case be remanded. I don't believe there was obstruction here. And with that, I will yield the rest of my time.
All right, thank you very much. Our thanks to both counsel. The case is taken under advisement. And that concludes our calendar for today. The court is in recess.